5 years ago, on January 6, 2021, the Capitol was breached. Hundreds were arrested. Trump's approval rating hit a historic low of 34%. In that moment, few would have predicted what would happen next. The then president faced potential criminal exposure not just politically but legally. Attorney General Merrick Garland appointed special counsel Jack Smith. Grand juries convened. Charges were brought. But everything changed when Trump won the election, not through courts, through power regained at the ballot box. Today, we're examining the complete collapse of the federal prosecution against Trump for January 6 and what it means for democracy, accountability, and the limits of presidential power. In July 2024, the Supreme Court issued a ruling that would reshape the entire prosecution. 6 justices sided with Trump. They held that former presidents have broad immunity from prosecution for official acts. Chief Justice John Roberts wrote the majority opinion, framing the central question: can the government rebut that presumption of immunity? The ruling didn't kill the case, it constrained it. It forced prosecutors to choose carefully which allegations they could still pursue. Jack Smith and his team had to decide what was official conduct protected by immunity and what was private conduct, potentially prosecutable. On August 27, 2024, they filed a superseding indictment, same 4 criminal charges, but narrowed allegations. The section dealing with Trump's interactions with the Justice Department was removed. That was deemed official conduct. Jeffrey Clark, a Dodge official who had championed false election claims, was removed as a listed co-conspirator. Gone. The focus tightened on one remaining allegation: Trump's pressure on Vice President Mike Pence to refuse to certify the electoral vote count. Prosecutors believe this was private conduct, not official, potentially prosecutable. But they were running out of time. An election was coming, and Trump was leading in the polls. On November 6, 2024, Trump defeated Vice President Kamala Harris. The political landscape shifted decisively. Republicans gained control of the Senate. 3 weeks later, on November 25, 2024, Jack Smith filed a motion to dismiss both the election case and the classified documents case without prejudice. His reasoning was explicit. It was based on Justice Department policy. A sitting president cannot be prosecuted while in office. That policy exists to preserve the presidency as an institution, to prevent a sitting president from being incapacitated by criminal trial. Smith's language in his motion was carefully chosen. He was not saying the case was weak. He wrote that the government stood by the merits of the prosecution. The evidence was sufficient. Conviction was possible. But sitting president policy prevented prosecution of sitting presidents. The case was dead. No trial, no verdict, no acquittal. Trump was not vindicated by a court. He was shielded from trial by his own assumption of power. Judge Tanya Chutkan approved the dismissal. It was over on January 7, 2025. Just hours before Trump's inauguration, Smith submitted his final confidential report to Attorney General Merrick Garland. 3 days later, he resigned from the Department of Justice. 2014-2025, the report was released publicly after initial legal battles over whether Trump and Judge Eileen Cannon could block it. The report is over 150 pages. It details prosecutorial decisions, evidence gathered, and why Smith believed conviction was possible. The core assessment: the office assessed that the admissible evidence was sufficient to obtain and sustain a conviction at trial. This is the professional judgment of a special counsel who had spent years investigating the case, presenting evidence to a grand jury, and preparing for trial. Smith also testified before Congress in closed session on December 17, 2024. His language there was even more direct. He said, "The Jan. 6 attack does not happen without Trump." He characterized Trump as the most culpable and most responsible person in the criminal conspiracy. He stated that he had developed proof beyond a reasonable doubt that Trump took part in a criminal conspiracy to overturn the election. The report outlined how Trump made false statements to state legislatures, to supporters, and to the media, how he was aware that supporters were angry, how he invited them to the Capitol and then directed them there, and how he refused to stop the violence once it began. The report is institutional preservation. It's a record that says we had the evidence, we brought charges, a grand jury found probable cause, the case was viable. but circumstance specifically, Trump's election prevented prosecution. Future prosecutors, future administrations, future historians will have this record. On January 2025, Trump was inaugurated. He took the oath of office inside the Capitol building that his supporters had stormed 4 years earlier. Within weeks, he began issuing pardons. 1,000 people arrested in connection with January 6 received full pardons. He commuted 14 sentences. His language was unambiguous. He said, "What they've done to these people is outrageous." He then initiated firings of Justice Department officials who had worked on the investigations. These dismissals were part of what Trump called ending the weaponization of the federal government. Jack Smith was gone. The investigation was over. The case was dismissed. But now Trump occupied the role that made dismissal possible. He was no longer the defendant. He was the president who dismissed his own case. The reversal is almost without historical precedent. In 2021, political analysts and legal scholars believed Trump could face decades in prison. His approval rating was at historic lows. His legal exposure seemed severe. But Trump ran a campaign centered on grievance. The indictments were witch hunts, he said. They were political prosecution, weaponization of the Justice Department. He focused on economy, inflation, and pocketbook issues. Voters prioritized those concerns over the legal charges. Trump won the election. That victory changed everything, not through courts, through power. The sitting president doctrine designed to preserve the independence of the executive branch became a shield that could be invoked only if Trump won the election, and he did. The precedent is significant. A president facing criminal charges can potentially escape prosecution by running for office and winning. The sitting president doctrine may now function as a de facto immunity for sitting presidents not from the courts, but from the political and prosecutorial consequences of their actions. Some legal scholars note that Smith's decision to dismiss without prejudice theoretically allows charges to be refiled after Trump leaves office in 2299. But political reality suggests that refiling is unlikely. Trump and his allies would have significant power to prevent it. The appetite for re-prosecuting a former president is uncertain. The question lingers. What does it mean for democratic accountability when the primary constraint on a president is electoral rather than legal? The aftermath of the pardons has been revealing. A report released in early January 2026 by House Judiciary Democrats shows that at least 23 individuals charged in the January 6 case committed new crimes between the attack and Trump's inauguration. These crimes include plotting the murder of FBI agents in retaliation for investigating the case, violent assault, strangulation, possession of child sexual abuse material, and reckless DUI homicide. At least 15 of those Trump pardoned had prior criminal records. One individual, Peter Schwartz, had 38 prior convictions dating back to 1999. 5 individuals, Zachary Allam, John Banuelos, Brent John Holdridge, Matthew Huddle, and Christopher Moynihan, were charged with crimes after receiving pardons. Charges range from burglary to kidnapping and sexual assault. Matthew Huddle was shot and killed by a sheriff's deputy in Indiana during a traffic stop weeks after his pardon. These cases are not abstractions. They represent human consequences. Brian Sicknick, a Capitol police officer, died of a stroke after being assaulted during the riot. 4 other officers died by suicide within months of January 6. The trauma extended far beyond politics. House Minority Leader Hakeem Jeffries has reconvened Democrats for a hearing on ongoing threats to free and fair elections and crimes committed by pardoned January 6 offenders. But Republicans have launched a separate panel investigating security failures on January 6, focusing on federal agencies and private companies, not Trump's role in the event. The narrative itself is being contested. How the event is understood depends on which investigation you follow. The institutional and constitutional implications extend beyond the immediate case. The sitting president doctrine exists for important reasons. It's designed to prevent a president from being incapacitated by prosecution. It recognizes that excessive legal jeopardy could paralyze the executive branch. But the doctrine was not designed for this scenario. A president who faces charges while out of office wins an election while those charges are pending and then invokes the doctrine to dismiss them. The precedent creates a vulnerability. Future presidents who face charges could potentially follow the same path. Run for office, win. Invoke the sitting president doctrine. Dismiss the charges. The pathway is now established. Whether it will be followed depends on political circumstance, not legal principle. Some legal scholars argue that the outcome was inevitable. The Supreme Court's immunity ruling made prosecution difficult. Trump's election victory made it impossible. Others argue that institutional choices could have led elsewhere. Earlier trial dates. Different jurisdictions, different prosecutorial strategies. But those are counterfactuals. What happened is what happened. The most serious charges a sitting president has faced since Watergate have been dismissed without trial or acquittal. Can a president accused of obstructing an election effectively control the Justice Department that investigates him? The answer in this case is yes. What does it mean for democratic accountability if the primary constraint on a president is electoral voters must remove him rather than legal? That question remains open. Does the DOJ policy against prosecuting sitting presidents need reconsideration? Legal scholars are divided. Some argue it's a necessary protection of executive independence. Others argue it has become a shield for presidential misconduct. As you consider what has transpired, sit with these questions. Was the outcome inevitable? Or were there institutional choices that could have led elsewhere? What does it mean for democracy that the charges facing January 6 have been dismissed without trial or acquittal? How will future presidents interpret the precedent Trump has set? Will the sitting president doctrine now function as an even stronger shield? What accountability, if any, remains? Is it solely electoral? And, perhaps most broadly, in a system where a president can pardon those who supported him in a riot, and where he cannot be prosecuted while in office for obstructing an election, what institutional safeguards remain against presidential abuse of power? Those are not rhetorical questions designed to lead you toward a conclusion. They are genuine questions about how democracy functions when one of its central institutions, the rule of law, encounters a president who has consolidated power. The answers will shape how we understand accountability, immunity, and the limits of executive power for years to come.